Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, be sure to subscribe to our channel. Law offices are Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So we received an interesting inquiry here on our YouTube channel. This has to do with vandalism. Let's see here. My wife was arrested for breaking my neighbor's two car windows with a hammer for having parked in front of our house. You know, this is interesting. My parents have had the same issue for the last, 40 years. You know, unless you're in a situation where you own a private road and you actually own the sidewalk, and that's extremely rare. That's like less than 1% of cases. You don't actually have the exclusive right to park directly in front of your house. You don't. I understand it's highly convenient to be able to park your car directly in front of your house, and it's wonderful to do so. But if you can't, you don't have the right to exclude people from doing so. And if somebody parks in front of your house, you don't have the right to say, "Hey buddy, move so I can park my car because this is my house." No. Now, if they park in front of your driveway, that's another story. But if they just park in front of your house, sorry, that's not your property. The actual physical structure is your property. The land under the house is your property. But once you get into the sidewalk and beyond, unless it's a private road, it is not your property. So you don't have the right to tell somebody to move. Now, let's get into the actual crime that was committed, vandalism. Vandalism is something that can be charged as a misdemeanor or a felony, depending on the damage you caused. If it's less than $950 worth of damages, that will be a misdemeanor under Penal Code Section 594, which carries up to 1 year in county jail. However, if you caused $950 worth of damages or more, now here in the state of California, that would be a felony under Penal Code Section 594, which is the same code, but that carries up to 3 years state prison. Now, if your wife has a clean record, she's never been in problems with the law, the worst thing that will really happen, this could probably get knocked down to maybe some community service, some fines, some fees, some sheriff's work. Obviously, she's going to have to pay restitution to the victims. But, you know, at the end of the day, when the dust clears, this will be a good lesson for her to learn, and for people and all involved. Just because you have a neighbor who's parking directly in front of your house, that does not give you the right to take a hammer and smash up his vehicle. That's a crime. What he did was not a crime. So now, of course, if there's no evidence that she was the one who actually did it, I would always say, at the end of the day, it's always safe to just remain silent. Never talk to the police. Remember your Miranda rights, because anything you say or do will be used against you in court. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel. Law offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court, call us now for a free consultation at 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who got accused of possession of a controlled substance. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorney.